Welcome back. This is part 3 of chapter 15, in which we're going to be talking about voluntary consent. We previously talked about mistakes and fraud. I had a chance to review the previous videos. Boy, that was scary. I had a friend tell me one time that I have a face made for radio, and I would tend to agree with him now that I've looked at those previous videos. Face made for radio. In case you're wondering, I am recording here from my house in San Clemente. It's a beautiful day, and really enjoying this, doing this recording in this third segment. And for those of you who are wondering, yes, I am wearing pants. Okay, so let's just get that out of the way. So we're in chapter 15, and by way of review, once again, we need 4 essential elements for a contract to exist. And those 4 elements are an agreement, consideration, capacity, and legality. And with all those functioning, we can have a valid and enforceable agreement. Chapter 15 talks about certain situations where an agreement may be lacking due to, number 1, a mistake, which we talked about. Number 2, fraud, which we also covered. And then number 3, which we will cover now in this segment. Let's see, mistakes, yes. Fraud, yes. And the third segment is, involuntary consent. There we go. And the first area of involuntary consent, and that is to say there's a lack of consent, and so there's no agreement, and so the agreement would not be considered enforceable, it would be considered voidable. The first area that we talk about is what's known as undue influence. What is undue influence? Undue influence is when you have a relationship between the two parties in which one of the parties exercises some type of overwhelming power upon the other, which results in the overcoming of that other party's free will. And they lack the voluntary consent to enter into the agreement, and the agreement is considered voidable. We see this in situations involving children. We see this in situations involving elderly people and elder abuse, where the other person overpowers the child, or they overpower the older person as far as dominating them and make it so that these people cannot exercise their free choice. This is a situation of undue influence. There are certain circumstances in which undue influence is presumed by one of the parties. And you have that in situations where there is a fiduciary relationship, that is to say a relationship based in trust, and where there's a duty of loyalty to that other person. The best example I can give of that would be a situation involving an attorney. An attorney might be handling a will or trust of an elderly client, and there may be a piece of real estate involved. And the attorney convinces the elderly client to sell to the attorney that real estate for a considerable bargain. And there's a conflict of interest there, of course, but it's arguable that as a result of that fiduciary relationship, it is presumed that the attorney is exercising some sort of undue influence upon that elderly person. The attorney I share office space with in my office, his name is Harold, a good attorney, been practicing for several years, and he primarily works in wills and trusts. And there are a lot of times in which here you will, when the person is getting older and they need to move into a convalescent home, he will make arrangements to sell their residential property. And there are times in which he has purchased the residential property, and he can only do so after he has thoroughly disclosed the terms of the agreement to the other person, and usually has to get a third party, another attorney, to look over the documents and agree that there is no conflict here, that it is a reasonable transaction, and that Harold, my attorney friend, is not exercising undue influence over his elderly client, which could be presumed, and Harold can rebut that presumption with the other attorney testifying on his behalf. So You got to look for that situation in a hypothetical, say in a test where there might be children involved or older people involved, and that would chances are be a situation involving undue influence in which the contract could be considered voidable and not enforceable as a result of one person overpowering the will of the other person. Undue influence. The next area is duress. Duress, and that's when somebody is forced into an agreement by way of blackmail, extortion, some other type of criminal activity, or just possibly physically forced into the agreement. But bear in mind, when we're exercising duress over someone, that threatened act must be wrongful or illegal. I will beat you to a pulp if you don't sign this agreement. There's the old movie The Godfather, where the Godfather told the man, okay, we will either have your signature on this contract or we will have your brains on this contract. That's a pretty good example of duress. Their life is being threatened, or they're going to be blackmailed. Something will come out if they don't sign the agreement. Things like that. Bear in mind that the threatened act, again, must be wrongful or illegal. If you rear end me on the highway and then get out of your car and say you're sorry and so forth, and I look at you and I say, all right, here's an agreement. You're going to sign this agreement right now and agree to pay me $20,000, or I'll take you to court and I'll sue you and take you for every penny you've got as a result of all my damages. And you become very afraid, and so you sign that agreement, and you write me a check for $20,000. But after I leave, you kind of calm down and you go, you know what? That wasn't right. I think that was duress. And so you call the bank and you stop payment on the check, and you give me a call and say, you know, that contract is voidable. It's not enforceable because you exercised duress. You threatened to sue me. Well, my threat to sue you is a lawful act. And so because it was a lawful act, it would not be considered duress. It would not be a basis for voiding out or making that contract unenforceable. If I got out of the car and threatened to beat you within an inch of your life if you didn't sign the agreement, the settlement agreement, that would be duress. That would be illegal or wrongful in nature, and that would be a situation in which the contract could be voided or considered unenforceable. But if I'm threatening a legal act, now that would not be considered duress, and you need to remember that. Hint, hint, hint. All right, here's another situation. What about economic duress? Generally, economic duress is not considered a type of duress that a person can get out of their contract. If this current time that we're in right now, if I contract with a local 7-Eleven to sell them bottles of Purell or bottles of water, let's go with Purell, for $500 a container package, I'm price gouging, and that's one thing. That's considered illegal in California, but it's not considered duress because it is merely economic duress, and I'm taking advantage of a situation, unfortunately, but it's not considered something in which you would be able to get out of the contract. However, you could press charges and have me arrested for price gouging. That's a whole different issue. So in order to have a situation where economic duress results in the contract being voidable or unenforceable, I have to create that economic duress. And the text on page 289 gives a good example of a person who's being audited for their taxes by the IRS. And the accountant comes in and says, let me help you with this. I'll help you with the audit. And a couple of days before the big meeting with the IRS, the CPA, the accountant, says, okay, you got to sign this agreement and pay me a lot more money. By waiting the way he did, the accountant put the individual in that situation of economic duress, and that would make the agreement that he had the person sign unenforceable, even though it was arguably economic duress and there was no threat of bodily harm or blackmail or extortion or anything like that. So when you do have economic duress, ordinarily not a situation in which the contract can be voided, only if you create that economic duress. The last section that the chapter talks about is contracts involving adhesion and unconscionability. We talked about that before in previous cases. Very quickly, if the contract is very one-sided, made by one party, and given to the other person on a take it or leave it basis, it might be considered an adhesion contract if the language is just so one-sided and unconscionable that it shocks the conscience of the court. And the court says, you know, this person didn't have a real choice in signing the contract. It is so very one-sided. We're gonna void it out and say it's voidable and unenforceable. I think we had the situation involving the father who had the potential son-in-law sign the contract, the prenuptial agreement, and say, take it or leave it, and you get $1 if this marriage goes south, and that's it. And that's kind of one-sided. It's kind of unconscionable. It's an adhesion contract because the father presented it to the potential son-in-law on a take it or leave it basis. There are a lot of standard form contracts out there that might be viewed as unconscionable, but you got to be careful about that. If they've been around for years, they're standard form contracts like a purchase contract for a motor vehicle, which we talked about. They're standard forms. It's pretty much take it or leave it, but they've been used for quite a long time, and the courts are quite familiar with them and say, okay, these are enforceable. They're not unconscionable. They're not one-sided, but they are adhesion contracts. And even though they're adhesion contracts, they are enforceable. Well, that pretty much wraps up situations involving where there's a lack of an agreement because of mistake, fraud, or lack of voluntary consent. Once again, once you've had a chance to review these videos and take a look at the material in the text, if you have any questions, feel free to email me at the campus email or my work email, tlbollinger@parkererwinlaw.com. I'm happy to answer any questions. And if you want to speak to me, let me know, and I'll give you my cell phone number so we can also dialogue on certain questions you may have regarding Chapter 15. I'll be downloading probably tomorrow the contents of Chapter 16, which we'll be covering on, I believe Thursday, a week from today. So hopefully you'll be able to see that as well. Until then, thank you and stay well.